Hello, everyone. Welcome to another great webinar from cpaacademy.org. My name is Vaughn Smith. I will be your moderator for today's webinar on helping your clients take back their lives from their student loans. So glad that you guys can be with us today. And no, that's not me on the screen. That would be our presenter, Christy. Go ahead and give us a wave, Christy. I'm just the gal behind the gal, making sure that everything is working a-okay for you guys on our end. So I would love to see if you guys can hear me and see the title slide and see Christy up on the screen. That way I know everything is working a-okay. And type in where you're coming in from in that questions panel and tell me hello. So you guys are already flooding it up in there. That's fantastic. Hello from Tampa. Yes, go Bolts. Woohoo! All right. We've also got Dallas. Sorry, Dallas. And then, I'm talking hockey. If anybody doesn't know what I'm referring to, that is what I'm referring to. Let's go with Flagstaff, Arizona. We have Mount Shasta. We have Colorado Springs. We have North Texas. We have Indiana, Myrtle Beach. Wow, looks like we are tuning in from all over. So thank you guys. So glad that you guys can be with us today. We really appreciate you taking the time to be with us for the next hour. We have some great information with a wonderful presenter, so thank you. This session does qualify for 1 CPE credit. You need to remain logged in for 50 minutes and answer our polls that will pop up throughout this presentation. Make sure you select your answer and hit that submit button for your CPE credit. And if you're having any issues during this session, the questions panel right here is the perfect place for you to tell me anything. I will do my best to answer your questions as quickly as possible. There are quite a few of you in here, so it might take me just a moment, but let me know if you're having any issues and I will help you out. I'm going out of order, so I'm kind of lost. I want to make sure that I go through everything. Handouts, let's go ahead and download those in your interface over to the right. If you do not have access in this interface, of course, let me know, but you also have your handouts available in your CPA Academy account. Your account is where you will see your issued CPE credit within about 24 hours, and you will find a recording of this session. I think I've covered everything, so it's time to welcome our presenter. Christy, the floor is yours. Please come on up and say hello.
Thank you. You sound a little bit like a sports presenter. Anyway, so my name is Christy Arkovich. I am a practicing attorney in Tampa, Florida. I've been practicing for about 28 years. I have a small firm. There's about 7, 8 of us or so. And we've been focusing a lot on student loans. And we've been doing that for several years. Basically, I used to represent the other side. I came from the dark side when I represented Sallie Mae, USA Funds, Terry, ECMC, all those back in the late 90s and early 2000s. And I since, at that time, I believed in student loans. I wouldn't be a lawyer if it wasn't for student loans, and I thought folks should pay their student loans back. But the problem is the system worked a lot better back then. And nowadays, it really is broken. Not totally, but there's a number of different areas that are very problematic, and it causes unsurmountable debt that folks just can't repay back. And so I kind of switched sides, and I learned a lot about the federal programs from a workshop that I had went to, and it grew from there. We now, probably 90% of our practice is student loan work. It's both inside and outside of bankruptcy, private loans, federal loans, you name it. The gamut is ours. We do pretty much all of it. While most of our work is in Florida, we do some work nationwide. With federal loans, we can help with administrative aspects of those, like disability applications and things like that, maybe IDR plans, income-driven plans. And then with the private loans, we're seeing a really significant help for our clients in private loans, because many of those are dischargeable in bankruptcy. I'm going to talk about that towards the end. Where we can get rid of those loans in a bankruptcy because they're not qualified educational loans, and we do that nationwide. I, in fact, have taught other attorneys nationwide on how to do this, and it's something that we are creating an advanced webinar for attorneys to try to help them with that. But this slide here talks about student loans should not be a life sentence. Where I got that quote from was a Kansas opinion that the judge was very dismayed on the limitations of In re Bruner, which was an old bankruptcy case. And it basically set forth the undue hardship test and made it extremely difficult to discharge student loans at the time. And unfortunately, that test is still with us. We have a lot of ways around that test. This is not a presentation on the Bruner standard and how difficult it may be to get an undue hardship. This is about all the other things that we can do instead. But I thought that was a fantastic quote, and that's basically where private and federal lenders want us to go, is they want this to be a lifetime loan for our clients, and that's not at all what our clients want. They want this loan done, they want it ended. So I think that Vaughn might have a polling question that she may want to put up now.
I do. Let's go ahead and bring that on your screens. First poll is up. I'd like to ask, do you currently try to address student loan issues for your clients? And thanks for the Sportcaster shout out there, Christy. That was awesome.
Yeah, you need to learn some NASCAR or football stats, and you'll be ready to go.
Right? Yeah. I pretty much just know hockey stats, so that's what I got.
Well, I understand the Lightning won the Stanley Cup this year. I don't follow it, so.
Oh, yes, we
Hearing
did.
all about it.
We like I play for the Tampa Bay Lightning, but all right. Yes, it was a fantastic series, and it looks like you guys are getting close to our threshold. We keep our polls open for 60 seconds, allow you to vote. Again, this is poll 1 of 4. So we're going to go ahead and get ready and close this poll down in 3, 2, and 1. And Christy, it looks like our results are 28% say yes, 54% say no, and 17 is like, I'd like to grow my business by offering this service. All right,
Okay.
back to you.
Well, good. That's perfect, because that means that a little bit over half of you are not doing anything about student loans for your clients now. So I think that this will be really good for you. The ones that are already doing some things, I imagine that you're not doing as much as you perhaps can. And then the ones who want to grow your business, this has been a tremendous lead marketing for us. We do a lot of bankruptcy work as well. We're not a volume practice by any means. But people with student loans debt have led to more marketing, more clients for our other practice areas. So, oh, guess what? I can't advance my screen.
Maybe try hitting the, oh, there we go. Yay, awesome, good job.
Okay. So I don't want to spend a lot of time on this, but student loans have grown tremendously over the past 10 years or so. As you can see from this chart, they vastly outweigh auto loans, mortgages, and credit cards. And the student loan debt out there exceeds both auto loans and credit cards combined. So when you're talking unsecured debt, something that's not a mortgage, you're talking about a huge area of our market. The delinquency rate, a lot of different national publications and different surveys and things show delinquency rates all over the place. So I won't quote a specific rate, but as you can see here, they are quite high. The delinquency rate exceeds all of those others, credit cards, autos, and mortgages. And in fact, the delinquency rate is a little bit of a, it hides the fact that a lot of folks are on forbearances, deferments, or income-driven plans with perhaps a zero payment. Those loans, had it not been for those programs, would also be in delinquent status, and they're not paying anything. So I think that the delinquency rate, when someone quotes it maybe as 10% of federal loans, it's a little bit of a falsehood, because it's leaving out a lot of data. There's also, I believe, a hidden default wave coming. There are basically forbearances right now and deferments through the COVID, the COVID CARES Act that was passed in March. For all those that have direct loans, that are those owned by the government, they do not have to make a payment, nor do they have interest accruing through December 31. But that's going to end. And that last extension from October to December was only granted by executive order by President Trump. And Congress, they just didn't get their act together to, reach a stimulus bill at that time that would extend that. We don't know what will happen after December 31, but we're having more and more clients come to us now, knowing that they're going to have this payment due and not sure what it's going to be based on. We also have limitations on how to cure a default. Administratively, the federal government only allows 2 ways to cure a default on a federal loan. One is consolidation and one is rehab. Well, once you consolidate your loans to a direct loan, you can't consolidate it again. You can only do that one time. And once you do a rehab or rehabilitation, you can only do that once in a 10-year period as well. So I call these things our get out of jail cards, kind of like Monopoly. You've got these two opportunities, and we're running into more people. Before COVID hit, we had a few people in the spring that had already used both of those get out of jail cards. Administratively, there's not another way to cure that default. They would be in default and potentially garnishment forever. And so it's a problem because you only have those two ways. Now in bankruptcy, there may be a different way that we can cure a default, but not everyone wants to file bankruptcy. And again, it's lifetime garnishment if that can't be fixed in some other way. So I think we're going to have an even higher default rate. The problem that a lot of folks, when they come to me, they have been listening to their servicer. Where they get their information from is either a series of governmental websites that it becomes somewhat of a deer in the headlights type of analysis. There's just too much information. They don't know what kind of loan types they have. They don't know what they qualify for, and they just move on to something else they can do because they just don't have time to try to figure it out. They don't even know if they get it right if they do figure it out. So what they do is they try to listen to their servicers. Well, the servicers represent the other side. They're nothing more than debt collectors. And so they have no obligation to the borrower to explain all of their options. And we see them omit many, many options that would provide lifetime savings for that borrower. And many of the times they're wrong. The Inspector General did a report last year that basically said 61% of the time, all the federal servicers that they audited all of them at the time, they were in non-compliance with whatever it is that they were doing, whether they were giving advice as to the options, calculating interest rate, putting clients in forbearance or deferment. They were simply wrong. And I like to say, well, as an attorney, if I misquoted the law, if I did something wrong 61% of the time, I'm pretty sure the Florida bar would have me disbarred by now. But the Inspector General was upset with the Department of Ed because they didn't disincentivize bad behavior. Instead, they just kept giving out the contracts to the same servicers that were doing the same things over and over again. And so it's a problem, and you cannot trust the servicer. And I want you all to try to help your clients understand that their servicer may not be acting in their best interest. Number one, we don't know their training. We don't know what algorithms they use. And in fact, they may be wanting to keep that loan on the books for their client, for their creditor, as opposed to get rid of that student loan debt, which is what the borrower wants. Another interesting thing is they often have incentives to get you off the phone faster. So you've got your client, a borrower, who's calling a servicer to ask what their options are. The person on the other phone is taking money out of their pocket to go ahead and explain all those options. If they get them off the phone quicker, they might get a bonus that week. And so that's a huge problem. So the first thing you want to do with your clients is encourage them not to just go with the flow. Don't just listen to your servicer. Don't pay it, don't ignore your student loans. Avoid that head in the sand approach. It's important that they understand their options. They don't want to rely on their servicer. Now, many of your clients are going to come to you and they're going to say, well, I've been in forbearance. Forbearance is awesome. I have no payment. It's great. I could get it over the phone. It took me no time at all. I didn't have to send a bunch of documents. Didn't take a lot of time. But it's a horrible, horrible long-term plan. It's good for short-term. If you have a car accident, you can't make a payment for a little while, forbearance is great. So I look at it as a short-term Band-Aid, and that's how I explain it to my clients, a short-term Band-Aid. It's not a long-term solution. What happens is the debt does indeed snowball, and it gets a lot larger. We've seen debt up to 10 times what has been borrowed. Normally it's 2 or 3 times, but that's even pretty bad there. If you have a client who graduates with $10,000 to $30,000 of debt, that might be payable when they first graduate. But if they have a series of forbearances due to they aren't able to get a job right away, maybe they have a job loss, maybe they have an injury or illness, maybe they have a pregnancy, maybe they're building a house, whatever it is, if they go into forbearance and the lenders and their servicers encourage this, years go by without payments. That 10 to 30,000 becomes 30 to 50 to 70 really quick. And if you've got high interest rates, that becomes an unpayable debt. And the CFPB, Consumer Financial Protection Bureau, they sued Navient a few years ago. Navient is the largest servicer in the United States. And they estimated that Navient added $5 billion of student loan debt simply because they pushed forbearance as opposed to pushing an income-driven plan. Income-driven plan is better for someone who is chronically what I consider underemployed. They're not making enough money to pay their student loan back as well as maintain a minimal standard of living. And so that's where an income-driven plan comes into play. You pay what you can, a percentage of your debt, and the remainder of the debt is forgiven after 10 years of public service, or 20 or 25 if not. But instead, folks are pushed towards forbearance, where there is no forgiveness. The loan just lasts forever. The other disadvantage with forbearance is that the interest capitalizes. I understand that most of our audience is CPAs, financial planners, folks of those types. And interest capitalization is something you're probably very familiar with, but every time someone rolls off forbearance, the loan, the accrued interest is added to a new principal balance, and it capitalizes. Now they owe interest on the new principal balance, and it goes over and over again. And so the question you want to ask your clients to get them to understand the impact of what their student loans are doing to their life is ask them, where do you want to be 10 years after graduation? If it's a new person, if they've recently graduated. If it's someone older, then you might not ask that question. You may instead ask, what do you think you will still owe on your student loans in 10 years? Or when do you plan on retiring, and how do you plan on dealing with your student loans? You might adapt your questions that way. What no one ever tells you about your student loan debt. When someone graduates, they don't really know how much they owe, I have found. They have an exit interview. It's often done by computer. There's a bunch of screens and so forth, and many of them don't retain much of the information there. They don't know how much they owe. They don't know what type of loans it is. They don't know who owes it. Is it their parents, themselves, their grandparents? Is it a co-borrower situation where multiple people owe the loan? They don't know any of that. So the first thing I do is try to figure out what they have. I sometimes will look at their credit reports. I'll look at the National Student Loan Database Report, nslds.org. It's nslds.org, and I have that on a later screen as well with resources. And that'll show their federal loans. But there is no database for private loans, only for federal loans. So sometimes if years have gone by, and a lot of clients come to me after 20 and 30 years, they've been dealing with these loans, they haven't been able to get them down any. They're making payments. Most people, they don't completely ignore their loans. They make payments over a series of years, but they're distressed because they're not making any headway. The loans are going up as opposed to going down, or they're remaining the same despite our client paying $750 a month. And so I try to find all the loans first. So I'll look at the national report for federal loans. I'll ask them what correspondence or phone calls or what their credit report might show on private loans. There is a report that the schools will have. I call it a tuition ledger. Some of them do as well. But basically, it's a list that the school maintains of what they charged and how they were paid. And I can identify additional sources of funding through that list. And I also use it for our private student loan discharges when I try to show the court or the other side how the loan is in excess of the cost of attendance, which makes it dischargeable. And that is a super argument that we've been making lately, and just got a client yesterday that we ended up with a stipulation of $30-some thousand of debt fully discharged because it was beyond the cost of attendance. It was a tuition answer loan. It was used for other expenses. Completely gone. Took me an email after we filed our case. It was very, very quick, but in part it's because we've been dealing with that opposing counsel for quite some time. They know what we are capable of and what we file and so forth, and they just wanted to avoid all that and get right to the chase. So you first of all want to find out, if that borrower if they're the only owner for the loan, only borrower for the loan. Private loans have a cosigner. So if you want to look and see how to tell the difference between federal and private loans will typically have a higher rate of interest. They will have a co-borrower, usually, not always, but probably 85% of the time. They also won't have any good payment plans. They're not income driven. It's whatever the debt collector basically tells them to pay. They also have interest only plans. Federal loans don't. They have an income driven plan, but they don't have interest only. And then with Navient's reports, for instance, it shows on the bottom of the list the private loans, and they also are referenced by SIG for signature. So that's one of the ways to tell for that. But there's significant differences between federal loans and private loans. Even the types of federal loans matter. So it's important to know what type of loans, not just the overall amount of debt.
Hey, Christy?
Yes.
Do you want to go ahead and launch our second poll?
Yes, please.
Okay, let's go ahead and do that on now. We have poll number 2 on your screens. We're just asking, what are the most problematic student loans for your clients? Private loans or federal loans? Wow, and you guys are voting very quickly this morning.
Ooh, looks like private loans is in the lead. I'm going to be a sports announcer too.
Yeah. Awesome. Good. I'm glad you found the panel. You can see that. Awesome. Okay, good.
Yeah, it looks like we have twice as much federal private loan problems, which is excellent because I'll spend some more time on talking about private loans here at the end, and I'll make sure we save plenty of time for that.
Okay, well, it looks like we are at our threshold, so we're going to go ahead and close this poll down in 3, 2, and 1. And it looks like our final stats was 63% private, 37% federal. All right, thank you.
Okay.
Back to you.
Good, good. Well, I understand why. With federal loans, there's programs, there's ways to cure default, there's income-driven plans. None of that exists with private loans, and I think that's a significant reason why. But I'm going to talk quite a bit about private loans in just a couple minutes here, so that's good. This screen here talks about avoiding a default with federal loans. When we talk with a client about what to do with their loans, we will often suggest that a default on a loan with private loans may be to their advantage, a strategic default, a way for us to negotiate the debt out of court, or even to file bankruptcy and try to get a discharge of those private student loans. It's the exact opposite with federal loans. A default will incur 25%. That's a huge amount. Doesn't matter what is taken in collection efforts, it's across the board, 25% is added when you default on a federal student loan, which is defined as being 270 days late or more without being in some kind of program, including deferment or forbearance, as well as income driven or whatnot. So you don't want to encourage a client to default on federal loans. Bad idea. The penalties include garnishment, administratively, 15% of their wages. They can do it with just sending a letter. That's all they need to do. They don't need to go to court or anything first. They can take in income tax refunds. You can do the whole injured spouse thing for any spouse of the joint return. They can offset Social Security up to 15%. It's a huge detriment on their credit report. And then also, you might have job issues with professional licenses. Florida is the only state right now that basically, if you have a healthcare license, an LPN, CPN, physician, you name it, it will be suspended if you're in default on a federal student loan. That is devastating. I've talked with the attorney for the other side with the department, not the Department of Ed, but the Florida Department of whatever it was that we're dealing with, and asked her, how do you actually think our clients are going to be able to repay the student loan if you're suspending their healthcare license? And they agree. They can't go on the record because they represent the other side, but they agree it's not a great law. It doesn't create any kind of source of repayment for the loans, but it is what it is. Also, a default can cause a client to fail on a home purchase. Let's see here. I can't advance the screen again.
It might need to be put like the focus back onto the slide. Maybe click on the slide and then use your arrow key. There we go.
There we go. Okay. Oh, this turned a little bit dark. I hope everyone can see. The first entry there is how to address federal loans. The most common thing is the income-driven programs. And there's differences between them, but that is the significant reason as to why people are able to address their federal loans. If they're making $30,000, maybe their payment would be $150. If they're making $50,000, maybe it'd be around $300. As opposed to if it's a $200,000 loan, it could be a $1,700 payment. So the income-driven plans, there's a number of different ones. We, about 40% of the time, will see their client is in the wrong one. They don't know why they're in the one that they're in. They just are. The servicer put them in there one day, and they've never been taken out. So the very first income-driven plan is called ISR, Income Sensitive Repayment. We don't see it very often, but usually once a year, I still will see that plan. That plan has no debt forgiveness. There's no way I would ever keep someone in that plan. That loan will never be over. And I still see it. So why do I still see it? Well, the servicers never told them that, when you got on this plan, debt forgiveness didn't exist. The only income-driven plan was ISR, income sensitive, and we've never switched you to something else, then why would they switch someone? It would result in forgiveness of their balance due, which is how the creditor makes their money. So they haven't suggested that they switch for some reason. Fortunately, we don't see that very often. Usually folks are in income-based repayment, IBR, or repay or pay, or income contingent. All of these programs are called income-driven plans. So when you have a client that comes to you and says, oh, I'm in IBR, income-driven, first of all, they think IBR is the only plan out there. It's income-based. It's not. Income-driven, consider it as an umbrella. Income-driven is the umbrella over all the plans. There is no income-driven plan. It's one of those initials I mentioned, IBR, ISR, ICR, so forth, or pay or repay. So when I say no one size fits all, there's one rule of thumb that I like to live with, and that is if you're a single person, oftentimes repay is the absolute lowest repayment plan. It's 10% of every discretionary dollar. How they calculate that is they take your adjusted gross income from tax return, subtract a percentage of the poverty level for family size, it's 150 for a repay, and then what's left over, it's 10%. And that plan was passed under President Obama, and it's a 10% plan. Most folks who are single, they're better off with that. If they're married, but their spouse makes a lot less than them, or they have a lot of dependents, often repay is fine. But repay has a significant drawback, and that is it absolutely counts the spouse's income, regardless of how you file your tax return. And so if you've got a client who makes $30,000, but their spouse makes $80,000, well, that's not so great because their student loan is probably going to triple. Not their loan, I'm sorry, their payment is probably going to triple. So one way around that is they take a step back. They go to an older program called income-based or IBR, and it's 15% of discretionary earnings, so it's a little bit more per month, but it doesn't count the spouse's income. But they do have to do two things. Not only do they switch to IBR, but they also need to file a separate tax return. So we often are doing an analysis of, well, what does your tax advisor suggest that you would have to pay in taxes if you were to file separately? And then we do the analysis of whether they should go on repay or IBR. Pay is a version of repay. Repay is revised pay-as-you-earn, it's sort of an amendment. But with pay, you have to have certain years of loans. So it's either pay or repay. I consider them basically the same thing, but pay is a little bit better if someone has certain years of loans. For this conversation today, I won't get into the details of all of them, but I did want to note that significant difference between income-based IBR and the pay or repay standard, and that is that tax return aspect. There's another program, and when I say tax return is filing jointly or not filing jointly and having to pay on a spouse's income. There's another income-driven plan called ICR. We see a lot of folks in ICR, and I think it's because of when that particular program was passed. Every one of these programs were passed to address a certain problem that Congress felt was out there. So each one of them, or whatever year they were passed in. ICR, income contingent repayment, the only reason a client would want that now is if they have a Parent Plus loan. The reason why is because it's the only income-driven plan that's available for those with Parent Plus loans. None of the others are. And that's important, and I'll talk with that about consolidation. You don't want to combine a Parent Plus loan with any other loans because of that reason. You'll be limiting that client for what they can do. And we'll see the other side do that. We'll see the servicers combine all the loans together. Well, our client was just, hurt significantly by eliminating their best options for repayment because now they're limited to ICR if they threw a Parent Plus loan in there with their own underlying federal loans that they have too. So what ICR is and why it's not quite as good is it's 20% of discretionary earnings. So it's double the payment that repay would be. It also uses a lower percentage, 100% of poverty level to determine expenses. So when you combine that 100% versus 150% of expenses, and you combine the 20% instead of 10%, you might have taken a student loan payment that would be $150 and turned it into $500. Well, there's a significant difference between those two numbers. And again, I don't know why I see people in there, but I'll see people in ICR when there's zero reasons they should be in ICR. So I believe that the servicers are not doing an adequate job of explaining the options for that particular person. So I covered a little bit with the differences. It may be that you won't know these differences, but I pointed out some of the more significant ones we'll see, and this is something we do. We analyze which income-driven plan will be best. We make sure we explain that to the client. A lot of times the client will come to us and say, well, I'm in this income-based repayment, but I'm not making any kind of headway. The loan is still the same as it was when I first started. And that's very, very common. The thing is that they were never told of the forgiveness. And after either 20 years for repay for undergrad or 25, or under IBR, it's 25 years. So it's often 25 years. Anything that they still owe is going to be completely forgiven. And that feature, I don't know, it's just not connecting with the borrower. They don't understand that until we explain how that works. And then we go into it a little bit further. As I note here, public service loan forgiveness will shorten the time to 10 years. So importantly, they'll still have the same payment, but instead of now 25 years, now it's 10 years. So that's pretty nice there. But for public service loan forgiveness, there are some issues, and I have a couple questions coming up about that. So if you'd like to do the next poll question, Vaughn, that would be a good time now.
All right, let's go ahead and bring up poll number 3 on your screen. Asking how many of your clients have had a decline in income in the past year? And again, this is poll number 3. We'll have one more. Right, and you're still voting very quickly, which is fantastic. Thank you, guys. All right, give you guys about another 10 seconds to get your responses in, but as of right now, it looks like we have 48% are saying 0 to 20, 37% saying 20 to 50, and 16% saying 50 or more. So we're going to go ahead and close this poll down in 3, 2, and 1. Thank you, everybody, for your votes. And back to you, Christy.
Okay, perfect. So about half of you, about half of your clients then have no income reductions this year, and that's fantastic. The other half are having between 20 or even a complete job loss. One of the things that we're doing with COVID right now is a lot of our clients believe that the CARES Act has applied to all of their loans, regardless of what type of federal loans they might have, whether they're the older FFEL loans that are not owned by the government, or direct loans that are owned by government, or even private loans. And they think their student loan payments just don't exist. And unfortunately, they're hurting their credit if they're not making payments when they could or should, even though they think the CARES Act applies. The CARES Act only applies to those governmental loans that are owned by the federal government, and those are called direct loans. It is a problem because a lot of folks think, well, I have federal loans. Well, they have the older federal family education loans in large part. That program was discontinued in 2010. But, as you can imagine, a lot of folks went to school before 2010, and 80% of the loans were FFEL loans back then. So we have a lot of folks who their loans are still accruing interest, but maybe they're under forbearance because many of the FFEL servicers have agreed to some of the governmental relief. They've agreed to do a forbearance, but they haven't agreed to waive interest. And that makes sense. Those loans aren't owned by the government, so they can make their own call on that. So unfortunately, those loans are accruing interest, but at least they have a forbearance. But we have private loans that often aren't agreeing to any of this. However, the private loans may have not been able to file suit because various states around the nation have had different moratoriums on civil court cases, whether it's evictions and foreclosures or student loans. But that can still report negatively on their credit. So we see a significant problem where a lot of private loans are hurting someone's credit, even though they think that the loans might be in forbearance. But we're encouraging people not only to do what Dave Ramsey and folks like that might suggest, which is pay your loans down, even though interest isn't accruing on direct loans, use the opportunity to pay double towards principal, or at least pay it so that it will decrease the principal. We're encouraging folks to go further than that. So basically, if you have a client who has 20%, 50%, or even 100% job loss, maybe coach them to think about bankruptcy options if they have private student loan debts. I see this as a wonderful time to clear the deck of a private student loan if I have a client who averages over the last 6 months less income so that they don't have disposable monthly income and they can file a Chapter 7. If they file a Chapter 7, that case is over in about 3 months. It is super fast. They'll be eligible in a couple years to buy a home, to do the different things that they want to do. Yes, the bankruptcy stays on the record for 10 years, but within 2 years, they're able to do most things again. And usually it's within a shorter period of time as that as well, particularly if they haven't hurt their credit much before they filed. But you can use that opportunity to a borrower to clear the deck of their private student loan. We can file a private an adversary proceeding to discharge private student loans. The basis for that is often that the private student loan is not a real student loan. Back in 2006, you had a situation where a lot of these lenders, when they saw the new BAP-CPA, the Reform Act for bankruptcy, when they saw that all private loans would be treated non-dischargeable the same as federal student loans, they thought, well, I'm going to loan some money. I don't care what it's being used for, but I want it to be considered a non-dischargeable student loan. And they loaned too much money. And so a lot of the borrowers out there thought, well, I shouldn't have been loaned this money if they didn't think I didn't have the ability to repay. And they didn't know any better. So they took the money. They used it for whatever, all kinds of things. And so those loans are often outside the cost of attendance, including room and board plus tuition and books and so forth, and they're dischargeable. There's also certain loans that are not school certified, dischargeable. There's K through 12, there's bar study loans, there's tuition answer loans, there's a lot of vocational loans, all kinds of loans completely 100% dischargeable. So a client can file a bankruptcy right now, be out in 3 months, we can file an adversary, their private loan is gone forever. That includes up to 200, there's no cap, but we've discharged $200,000 of private student loans for an individual. There's no dollar amount that we're looking for. We're just looking for, is it a non-qualified educational loan? It may be that they went to an institution that is not eligible for federal funding. There's a lot of Caribbean medical schools that fit that bill. There's other schools as well. Those completely dischargeable. They may have an ineligible student issue. Maybe they weren't a federal taxpayer those years. There's not a lot of case law on that issue, but it is something we have brought in the past. Maybe the school hasn't been open for 2 years. There's a lot of things that require for the other side that they have a burden of proof to show that this is a qualified educational loan. And they either don't want to take the time, spend the money with their attorneys to show that it's a qualified educational loan that will survive a bankruptcy. And so it's a good opportunity to clear the deck of that. Another thing that we've found very useful right now, when we have a client out on furlough or something like that with an older client, is they only have a few years till retirement. And so with COVID, they're a little scared about going back to work. They're concerned about the safety measures that their employer is taking. Well, why not take this opportunity to think about a total and permanent disability? If they're not able to return to work and they can have a physician that is willing to certify that they're unable to engage in substantial gainful employment, my definition is go to work full-time doing what you used to do. That's not actually the definition, but that's how I explain it to a client. We haven't lost one of those applications yet. So I'll have an older person who they're deciding whether or not to return to work. Their job isn't safe. Why not take this opportunity to do a total and permanent disability application if they're eligible? And then maybe they'll return to work later, in 5 years when things are better. There is a 3-year monitoring period after a disability application is approved. So it's important that they don't return to work, at least not making more than the poverty level for their family size for the 3 years after the program, after the approval of their discharge. But those are 2 opportunities during COVID that you can encourage your clients to, clear the deck, get rid of their loans, whether it's federal or private, during this period, and then perhaps they will be better off for it later. Let me see. Okay. So besides the income-driven plans, there's other things too. I just wanted to touch on these very quickly. You've got the Public Service Loan Forgiveness Wrong Payment Fund. Basically, Congress discovered that, hey, we've got a lot of folks on public service. They're not making the income-driven plans. They don't know about the income-driven plan payments. And so we're going to commit this $350 million fund for folks who have direct loans. So they have the right kind of loans, but they're not making the payment that they should. And so this fund allows for them to get a public service loan forgiveness recovery. The borrower defense to repayment, that's not going so good. This is for clients who happen to go to ITT, Corinthian, Everest, schools that are allegedly a for-profit fraudulent school. and so forth. So they have filed an application to seek discharge based on fraud. Secretary DeVos has very readily seems to deny those applications. We have had some that have had a little bit of approval. They've gotten 10% reduction of the principal debt and waiver of interest during the review period. Very small compared to the loss to that client. Usually those diplomas, those degrees are useless. I've had more than one client tell me, I was encouraged by my employer to simply leave this degree off of my resume. It doesn't look good that I went to this particular school, and they don't have any, they don't give any kind of credit towards having a degree from this particular school. So unfortunately, I liken going to those types of schools sometimes similar to our lemon law for vehicles. It's like you bought a car and you can't drive it off the lot. Same kind of concept, but Secretary DeVos has readily been denying most of those claims, but it does still exist. You've got the disability applications I mentioned previously. There is a possibility of settling federal student loans, but they don't settle very well. So it's not something we steer for. But if we do settle it, we usually are settling lower dollar ones while it's in default where we can get the best benefit. If you have a client who hasn't paid for 10 or even more years, oftentimes that case has been referred to the Department of Justice. They do settlements as well. They require a 20-page financial statement, so you get quite a bit into detail as to the collectability of your client. But that's something some of you may be interested in doing. I have a couple a year. I don't have a lot of those though, but they often need to get those taken care of. So you can do a settlement with the Department of Justice. And then you have all the counseling regarding the penalties and how to diminish those penalties by curing the default and things. Now, to cure a default, I'm just going to touch on this real quick because I want to make sure we have plenty of time for private loans. You can do a rehabilitation, you can do a consolidation. There are differences between them. A consolidation is much shorter. It only takes about 45 days to have a new loan pay off the old loan. A rehabilitation takes 9 months, so it's a little bit longer, but it is a little bit better for their credit. Both of the ways to cure a default will decrease the amount of penalty. So in other words, instead of 25% collection costs, it decreases to 16.5% or 18%, depending on which option is chosen. So it drops at about 10%, but it still leaves quite a bit on there. But the most important thing to know about consolidation and rehab is that don't do both of them. You know, if you do both of them for your client, you've used both of their get out of jail cards, which means if they ever default again, there's no way back out. So we're very careful about picking the best one for them and leaving one in their pocket for later if they should need. Rehab, the nice thing about rehab is that payments can be as low as $5 a month. You've got a 9-month period where the client is making a negotiated payment. After the end of that, then the default is removed from their credit, and then they're eligible for the income-driven plans. With consolidation, again, the new loan funds in about 90 days, so it's a little bit quicker, and then they're also eligible for any of the income-driven plans. The thing with rehab to know is that oftentimes they'll come back with a payment that's fairly high. You don't have to agree to that payment. We use a 4-page budget with our clients, a very comprehensive budget. I tell my clients to fill that out as best they can. I want every single expense that they have on that form that I can use. And then I argue under the CFRs that, which are the regulations that the servicer is required to follow, I argue that they have to come up with a reasonable and affordable payment. So I give them this 4-page budget. I propose a particular amount as an affordable payment. I take into account their other federal loans that they might have, other types of loans that they might have, and even garnishment if that's occurring. And normally the other side will agree. And so they'll agree to whatever payment we propose. So you can reduce those payments, but they do have to make 9 payments, 9 out of 10 payments, timely. They can't prepay all at one time, but rehab is a way for them to rehabilitate their existing loan and to get back into a performing loan status. It does require a signed agreement though. We have a lot of folks who they're in rehab for 36 months. It's a 9 to 10 month program. There's no way they should be in there for 3 months. What they're in is a voluntary avoid garnishment type of payment. I don't like those. You know, those have harm to the credit each and every month. Why not get them into a rehab where it cures the problem and removes the negative entries from their credit? Not the fact that they've missed the payment, it removes the default itself. Let's see, I can't see what the, I think it says consolidation there under there. I have the screen blocked by the GoToWebinar things over there on the right-hand side. when a client comes to me and they speak about consolidation, first of all, they think that it's only there for reducing interest rates. When you consolidate a note for federal student loans, it's a market-weighted average of what the notes were previously. So it's not really supposed to reduce interest rates. That being said, some of the newer loans do have much less interest rates than some of the older loans. But what we look at consolidation does is it actually combines multiple accounts and limits the number of servicers, which is very, very important, because I'll have clients who come to me that one aspect of their loans are in default, the other aspect is current, and they don't even realize this. They think they're current on all of them. And they have to have those servicers talk with one another to have an income-driven plan. Otherwise, they'll have 15% from this one, 20% from this one, and it adds up. So I think it makes it a lot easier for them later in life if they consolidate. But that being said, a consolidation will go ahead and take the interest, and it will capitalize that interest. So I don't jump right to consolidation if there'll be a lot of capitalization without at least advising the client of the impact of that capitalization of that increased interest. Many folks don't have that much, though. They've been on forbearance where every time they come off forbearance, the interest is rolled into principal, so they don't really have that much interest that will be capitalized. But the consolidation has a very, very important point, and that is it changes a loan type. So it's kind of like a refinance. You're basically taking the older FFEL loans and you're making them the newer direct loans. If you wonder why that's important, know that the CARES Act only applies to direct loans. Repay, the 10% program, only applies to direct loans. I'm sorry, I should say it differently. Direct loans only apply for repay. Repay is not available for FFEL loans. Public service, direct loans only. FFEL loans aren't eligible for that. There's a lot of things that direct loans have as advantages that FFEL loans don't have. And when you do a consolidation, that is the easiest way to change the characterization of that loan type. And one of the problems I have with servicers is they never explain that to someone. They never explain that you have the wrong loan type. Your loan type is old, it's not eligible for all these things. They just don't cover that. But there is one issue with consolidation down here, one time only. You can only consolidate to a direct consolidation loan once. Once you do that, you can't consolidate ever again. And you also cannot combine your private loans with federal loans. So under no circumstances can someone have all of the private and federal loans with one loan. It just doesn't happen. They can have them with one servicer, but they're still always going to be separate. And then lastly, remember, leave the parent plus loans separate. You never want to combine them. I'm not going to cover this much, but there is a way that you can cure a default in a Chapter 13. It's something that's not done very often, but it's a third way to cure a default. It's the only way left if someone has already done both a consolidation and a rehab. Refinance, real quick. Basically, the average interest rate for a federal student loan is 6.8%. That's pretty high. In today's market, when you have 2 and 3% for mortgages, 6.8 is very, very high. Grad loans are 8 and 8.5, even higher. So refinancing to a private student loan is not a bad situation if you have a client who makes a lot of money. For instance, if income driven is not going to help them, let's say they make 80 to 100,000 or more. Income driven may increase their payment from what a 10-year standard or even 25-year extended fixed payment would be. So they don't really want to be in an income driven plan. They're not getting any benefit from that. Let's say they're working and they don't need forbearance or deferment. Then let's say that they're healthy. They're not going to need disability, or they have a disability insurance plan, even better. So if they refinance to a private student loan, the going interest rate right now is probably around 3.75–4%. So it might be a good idea for someone making a good amount of money, but they lose a lot of protections. What happens if they get injured? What happens if they're going to retire soon? What happens if the job market falls apart? Whatever it is, they're going to lose the benefit of income-driven plans, debt forgiveness, disability discharge, as well as extended forbearance and deferment. Private loans have a little bit of forbearance and maybe deferment, but not much, not like federal loans. Federal loans that can go on for years, unfortunately. And so just make sure that they understand they're losing those protections. So I only recommend it for someone who usually is younger, very healthy, making a ton of money, probably going to make even more later. Then, reducing interest is a fantastic idea. But otherwise I would try to avoid it. There are ways to find additional information. StudentLoanHero.com has a bunch of information about this. LendEDU.com. You can shop lenders. There's about half dozen at any given time. It has their actual credit scores they're looking for, the interest rates they're able to do. They do soft pulls of credit, so a client can go right on there and do the application on those sites directly. Now, the rest of the time, I'd like to talk about private student loans. With private student loans, right before we go here, there is one more poll question before we get to private student loans. If you want to run that, Vaughn, please.
You and I are on the same page. I was just going to ask. Let's go ahead and bring that up on the screen. And do any of your clients work in public service, government, or nonprofit? It's yes, no, or I'd like to learn more about public service loan forgiveness. And this is our fourth and final poll for credit. I'll give you guys about another 15 seconds to get your responses in. All right, gonna go ahead and get ready to close this poll down, but it looks like we've got 40% saying yes, 43% saying no, and 18% saying they'd like to learn more. So closing this down.
Okay.
Back to you.
So those of you who have heard about public service, you probably have also heard that 99.5% of those who have applied for public service have been denied. The reason for that is that folks haven't known what loans to have. Only direct loans are eligible for this. They haven't known that they need to be in an income-driven plan. They haven't known what a qualified employer is or even how many payments are needed. All these questions that they have aren't being answered by the servicers. It's not that hard. I can explain in 30 to 60 seconds what it takes to be eligible for public service. One, you have to have a direct loan. The NSLDS report will tell you whether or not it's direct or FFEL loan. They have to make an income-driven plan payment. That's one where you submit your income every single year and you continue to renew it. They have to be working full-time. That's 30 hours or more. The or more is if an employer requires full-time to be more than 30 hours, say 35 for insurance reasons or something like that. And lastly, it has to be a qualified nonprofit. There's a form for that, the Public Service Loan Certification Form. It's a certification form. It's not required, but annually they can send it every single year. Their employer will fill out what type of tax exempt entity they are, primary purpose of business, all that stuff. It's only 4 or 5 questions, pretty easy for them to do. And your client will get a running tally of how many months they've accrued towards public service and how many months they have yet to go. I talk to people now who have no idea there's a form. No one's ever told them there's a form. They would know exactly where they are if they had the benefit of this form. Nobody knows. I talked to clients who have the wrong loan types. One of our clients was, he submitted as a weather person for the National Weather Service an application after 10 years of payments. He knew to consolidate. He'd read that on the website somewhere, but he had consolidated to a FFEL consolidation loan, still the wrong loan type, not a direct. No one told him. So we have done some class action suits to try to remedy that. We have one pending with Great Lakes right now. There are attempted fixes in the HEROES Act. I understand that Congress is trying now to pass a law that basically says that this public service loan forgiveness should apply to FFEL loans. Maybe something like that will pass one day. Right now, it's only eligible for direct loans. But as you can see, there's only 4 or 5 elements. It's not that hard, but servicers cannot communicate or choose not to communicate that information. So if you have someone who believes that they're eligible for public service, they need to take the bull by the reins, make sure that they qualify, do these 4 or 5 things, and they'll be fine. But if they don't do those things, they will be denied, definitely. So I just wanted to touch on that public service before we went on here. So private loans, they have high interest, between 10, 15% we often see. They've got co-borrowers, grandparents even are on these loans. They don't care what the person's budget is. They'll say, well, you've got to pay $750 or $1,000, and the client might make $20,000 a year. Are you kidding? They don't have money for that. So they have high payments regardless of the budget. We actually will encourage folks to maybe strategically default on those. We can settle them outside of court. We're looking for payment plans in those cases that are usually 3 to 5 years. We often are around the 4-year time period. Maybe we're paying 30 cents on the dollar. There's no interest usually though. So any settlement that we reach on behalf of that client, every single dollar goes to that reduced principal amount, and there's no interest on that loan. That is fantastic. That ends that loan. Our little mantra is basically we want to make sure that their loans are affordable, sustainable, and with an end in sight. We don't want them to last forever. We want an end in sight. So those options of settling a private student loan outside of bankruptcy, that exists, like I said, outside of bankruptcy. You don't need a bankruptcy for it. But when we have a higher dollar loan, typically a bankruptcy is a better result. The reason why is because, have you ever tried to pay 30% of a $150,000 loan in 3 or 4 years with a limited salary? Some of our clients just can't afford that settlement. Even if we can get it, they can't afford it. They also could have a 1099 and a taxable event if they do it outside of bankruptcy. That's significant. If it's a $150,000 loan and we're getting $100,000 written off, that under Section 108 of the IRS code is income to them. They could get a 1099 and have to pay taxes on that. In bankruptcy, that's not the case. With bankruptcy, we have a discharge. Any dischargeable debt is not taxable. So that's something that's a huge advantage. The other thing, when I mentioned total and permanent disability applications for federal loans, those also currently are not taxable. The budget will have to be renewed in 2025, but assuming that it is, it'll remain non-taxable. Whenever possible, we try to reach a resolution that we have a end in sight for those loans, and we have drastically reduced interest, if any, and we have no taxable event. And we're able to achieve that with these private loans. Another thing that we might do is a consumer law violation. A lot of private student loans, they're making phone calls all over the place. They're saying the wrong things. They're taking collection efforts that they can't take. Maybe the client had filed an old bankruptcy. Well, we can reopen that bankruptcy. And when we reopen it, we find that, well, if we win, and this is very important, if we win, every collection effort that they've taken since the general discharge, let's say they had a bankruptcy back during the foreclosure crisis in 2008 or 10 or something. We reopen that bankruptcy. We file an adversary to discharge their private student loan debt. Everything, we win. Let's assume then that they've been writing and calling and doing all this stuff in the meantime. Ever since that general discharge back in 2008 or 10, everything they've done has been a collection law violation, because my discharge in bankruptcy now relates back. It's kind of like Schrodinger's cat. Remember the cat in the box, that physics theory where you don't know if the cat's dead or alive until you open the box? Well, we're opening the box. The cat doesn't die now. The cat died when you forgot to feed it back in 2008 or 10 during that other bankruptcy. So it relates back to that prior bankruptcy. And that's the carrot and the stick. We might offer a small carrot. Maybe, hey, we'll pay you a little bit of money. The stick is, if they lose, they're going to owe collection law damages under the FDCPA, Fair Credit Reporting Act. Under any local act, here in Florida, we have a Consumer Collection Practices Act. Maybe an FCRA type violation, maybe TCPA, cell phone calls, you name it. All those potentially could be violations. Now, we can't bring them in every state. Here in Florida, we actually have an 11th Circuit opinion that somewhat limits us for doing that, but that doesn't exist in other states. So we are able to get that type of damage in those other states. So if your client has suffered an impact to their income, it's a good time to maybe do an out-of-court settlement on private student loans. They usually have to be at least 6 months in default, though. So you'll have a time period to negotiate with them. Or they could reopen an old bankruptcy, or they could file a new bankruptcy. Any of those options will help get rid of that student loan debt. And none of them involve paying 85 cents on the dollar or even 60 cents on the dollar. We're talking about much, much lower numbers, lower than 50%, often 10, 20, 30, 35% range, maybe 40, but somewhere in that lower range. And in the grand scheme of things, what is the client actually paying? A lot of times they're paying what they borrowed. What they're not paying is this enormous amount of interest that has piled on that loan for the last 10 years. And so they feel good. They feel good because many of them, they don't want a free ride. They're not looking for, like a free house in foreclosure. They're not looking for that. They're just looking to pay what they can reasonably afford and consistent with what they feel the value of the school that they went to and what they actually signed up for and the loans that they took. And we don't need an act of Congress to do any of that. We don't have to have the House agree with the Senate to have the president sign off. We need none of that. These types of things are all things that you can do now, whether it's private loans or federal loans, to decrease student loan debt. And that's why I called the seminar here today, How to Take Your Life Back from Your Student Loans, because that's what we're doing. A lot of these clients, when they come to see me, they think they have no life. Unfortunately, I've had many people say they've even contemplated suicide. It's a major thing. It's caused problems with family members, with their co-borrowers. They want to pay that loan, they can't pay their loan, their parent is mad at them. So whatever you can do to diminish and decrease the student debt they will love you for life. It's the happiest area of practice that I've ever been in. And I hope that today you've learned some things and some tools that might help you to help your clients decrease your student loan debt. We're available if you should need. I do have some resources here. This studentloans.gov repayment calculator is how you can calculate the income-driven plans. You can point your client to that as well. When we have a client who has calculation issues, they think that they've paid more on the loan than what was counted, or maybe something went wrong with the payment history, the ombudsman is good for that. They have more specialized, highly trained folks that work for that department. We usually put them to work on any kind of calculation errors of any time. The federal database, the nslds.ed.gov address is there. I have an ebook, How to Take Your Life Back from Your Student Loans. It's free. It's on my website. My website is at the bottom there, christyarkovich.com. We have a blog. We regularly post about new things that are happening all the time, new ways we get rid of debt, amendments to laws, you name it. I also have a student loan survival center, a lot of information about different loan types, how we solve them. There's a lot of podcasts and videos on my website. And here's my contact information, my law firm here in Tampa, Florida. We have 3 attorneys, a few staff members and such. My email and web address are there as well. So I'd like to open it up for questions if we have a few more minutes. Vaughn, how do you guys do questions?
We're actually over time right now, so we will not be able to have any time to address questions, but I will send you a full report of all the questions that have come through, so that will be sent over to you in just actually at the end of the day, Christy. So, but thank you so much for all of this fantastic information. We really appreciate your time and sharing your expertise with our audience, Christy. So thank you very much about that. And as a reminder to our audience, we'll be processing your CPE credit. That'll be made available to you in your account. I can see, thank you a ton, great information. Thank you so much. So all of these fantastic comments coming through the questions panel,
Great.
Go ahead and put them into our evaluation form that should be in your inbox right now. So jump on over there and put all this great information into there, because we welcome and appreciate all of your feedback. You can also find that in your CPA Academy account. So I think that's it for now. Check out our schedule on cpaacademy.org, because I hope to see you all on future webinars. But for now, have a great rest of your day. Thank you, everybody. Thank you, Christy, and I'll see you guys next time. All right, bye.
Okay, all right, bye-bye, thank you.